Welcome to our lecture in forensic accounting on evidence management. First, let's discuss the rules of evidence. This is basically what allows you to admit documents into a legal proceeding, and weight is given to the type of evidence that is admitted. So evidence is your testimony, writings, any material objects that have to prove some type of fact. There are two kinds, direct and circumstantial evidence. What you see in the media and in quite a few outlets is circumstantial evidence, but the law doesn't really put one over the other. So direct evidence is, as the name implies, directly proving a fact. You don't need to make any inferences or any type of presumptions, which is completely the opposite of circumstantial, because that's evidence from a fact that has to be proven indirectly, so based on the circumstances. There are relevance requirements. Evidence cannot be admitted into a proceeding unless it is relevant. So here we have circumstantial evidence. This is going to prove the fact directly. This is your testimony, and it doesn't necessarily have to be that direct link. You can have it as part of several inferences to prove the point. Inflammatory is basically the evidence, the value that it would provide has to greatly outweigh the fact that this could be not legal. And so now you're going to kind of bias a person into something. Then you have plaintiff's character. Whether their character is good or bad, that's mostly inadmissible if you're going to try to prove some type of function or activity happened because of this occasion. We have then evidence of habit. This may or may not be admissible, and it usually is when it's repeated or you really need it towards your case. We have exclusions, as always, to everything, right? And then these exclusions are special circumstances, and the courts pretty much determine that. You also can have evidence of liability, which you have to prove liability insurance, and you have to prove that it's admissible in the federal courts. So we have privileged communications, and these are protected relationships. Attorney-client is one. You may also have your relationship with the priest, and there are certain communications that, for example, employee communications and work that you're not allowed to discuss. Now, any attorney that requests accounting information, that will come under privilege. But remember, as accountants, we do not have accountant-client privilege. So based under federal or state law. So we don't have that protection. The only protection we have limited protection, I would say, as it relates to tax advice. We have medical privileges, in which usually in a civil type of lawsuit, and basically in that case it's usually your physician or psychiatrist. And then you may also have spousal privilege, and this pretty much lets one spouse refuse to testify against their other spouse. And basically it means that communication is privileged between the spouses. You may also have a religious. That's the most common other type with your priest. And usually in practice, there's disputes as to about governmental privileges, anything that's known. So basically if it's known, it's not privileged. We have hearsay, and that's either oral or written, and other than one made by somebody declaring it at the court. So basically if you're saying something on behalf of someone else, usually hearsay is not admissible. In any type of legal proceedings, the only way is as an expert witness, and that's where we accountants come in to serve as those expert witnesses. So a statement that appears to be hearsay usually has to prove something. So it has to be a legally operative fact. It has to have some type of effect on the listener, the judge, or the jury, and you have to kind of give some state of mind as to who you're declaring it about. And then there are rules, right? These are three concepts that underlie the exceptions. So if trustworthiness, if you're unavailable, or there are just some practical considerations as well. So then we have the authentication requirement. And in order for evidence to be admissible, you have a document or other material. So documents are evidence. Usually provided must be authenticated or identified to prove the claim that it's doing. Then we have the best evidence rule, which is also referred to as the original writing rule. And this proves through writing or recording or picture or an original writing that what it's representing. attorneys can get around this rule. Lucky for them. Unfortunately, we accountants cannot. There is demonstrative evidence, and this is where an item illustrates testimony, but it doesn't really have value in proving itself. So it could be like a chart, a diagram, org chart, things of those nature. There are special rules in these administrative proceedings, right? In criminal cases, you have to prove beyond a reasonable doubt the information, right? So you are guilty unless you can beyond reasonable doubt. Now, in administrative proceedings, that's completely different. That usually follows the Federal Administrative Procedures Act. So Federal Administrative Procedures Act. And states have their own. So we as forensic accounting experts, we should get advice from our counsel as to what the obligations are when you're being engaged at that point. So the tone of the proceedings, that's a really broad statement, and it's really the procedural due process. And they are, so basically all the parties with experience, you have to, and anybody that's not familiar with the procedures, you pretty much have to find out the formality and what you have to do when you're in the court. Then we have the residuum rule. This is an exception. And this is kind of like a relaxation of all those formal rules. And basically there is that no finding may be supported solely by your hearsay evidence. So that's the main rule. So you can't really have it supported, by that. This thing is going crazy. So now we are talking about the expert witnessing in forensic accounting. And here is some advice by Michael Mostek. And basically, you should directly retain the consultant as an attorney. And then the agreement should be between the attorney and the expert witness. The investigation has to be conducted with the direction of the attorney. And the attorney should always be present when the consultant first meets with the client. And then we have a 2014 top initiatives in the U.S. relating to technology. And one of the things that you should do is maintain and retain data, make sure that it's private, there's IT risks and compliance. So there's a whole gamut of stuff that we should do, and definitely leveraging technology is one of them. So in computer evidence, you want to protect the software, the hardware, any type of email, so anything documenting computer evidence. When you are managing evidence, you don't want to mark or staple in any documents that might go into the court. You want to record the documents, how they were obtained. We call that the chain of custody. You may also want to use see-through folders just to make sure you don't put all your fingerprints all over it. And you want to store the original documents with any type of papers in a fireproof safe or some type of locked cabinet. And that information should be protected on your computer, have a password, backup, and backup. That's critical. We all know that frustrating feeling when we lose all the hard work we've been doing. And when you're looking at documents, certain questions that should come up as a forensic accountant are the invoice numbers. Are they sequentially? Was there a big batch skip? If there's no tax on an item, why? If it should be. When there's no ship or freight costs, and to show that something should have been shipped, and that even if it's waived, it should have it on the document. And if there's very minimal detail on the invoice, that would kind of hinder what we're trying to do. So this is just basically how the forensic accountants, we have to deal with so much information, right? Whether it's electronic or transactional, some type of historical report. So this is becoming voluminous, and dealing with all of this information is time consuming, costly. So you really have to add all of that complexity when you're actually engaged for a forensic audit. And then a computer, online forensic extractor, basically, that allows us, it's actually obtained from law enforcement officers, and it's a free Microsoft device, which is called Coffee, right? Computer online forensic extractor. And it's kind of installed as a USB flash, and basically this is like a forensic tool, and it contains 150 commands that really can reduce the amount of time that you're spending gathering this digital evidence and trying to decrypt passwords and and basically just understand how the data is stored on your computer. Then we have other digital multifunctional devices. So multifunctional devices, and so these are basically where you have just hundreds and thousands of records. There's a lot of internal memory, and then you've got a copy, print, scan, fax, you name it. So here the individual basically are kind of walking away from the machine, and everything stays in the machine. And we are done with this lecture.